Hi, welcome to North Alabama Law Review presented by Johnston and Weston. I am your host, Shauna Hill, and today we have with us two of our top litigators who specialize in business contracts, insurance disputes, probate, and estate. So today we have Christopher Weston and Bennett Driggers. Welcome, guys.
Welcome. Thank you.
Thank you for coming. So let's dive into today's trending topic. We all know, living in Alabama, the bad weather we deal with. We deal with rain, floods, tornadoes, all that leads to insurance claims. So guys, help us when navigating these insurance claims and the problems that we run into.
Okay, yeah. This being, we're a couple shows in at this point, and so we'll kind of go into more detail is whenever you're dealing with an insurance claim, and Bennett's gone over this in the past, and I've gone over this more generally in dealing with contract terms, is that the very first thing you look at, where this very, very first starts, is your insurance contract. Again, for those who may not have seen the other episodes, insurance is a contract, and both parties are bound by the terms of that contract. And so knowing those terms, it lays everything out. Insurance has been around for decades and decades. And so it has gotten more sophisticated as time has gone on. And so there are narrower and narrower cracks in getting around the language or the terms of your contract. And so knowing that is always the first step. And as Bennett has talked about previously, again in other shows, is we're dealing with, notice. The very first thing you have to do when you have damage to your home or some other piece of property that's insured is give notice. And you need to do that relatively quickly. Now, if, unfortunately you've been injured, that doesn't mean you need to ignore your broken arm and immediately call your insurance company. But within a reasonable time, and sometimes there are time limits in the contracts themselves, but you need to give notice within a reasonable time, and you need to tell them what happened and give them an opportunity to come out and evaluate it. Most people know this, hence claims adjusters, estimators, evaluators, contractors, people that your insurance company sends out to evaluate your damage, okay? And so you do need to make absolutely certain that you give that notice and that you at least reasonably cooperate with whoever they send out to come and evaluate your claim. Once that is done, they will go back and forth usually, and then there will be some offer to cover the damage, cover the claim. And that's where disputes usually arise, either whether or not damage is pre-existing, whether or not it was caused by that specific incident, whether or not it is excluded. And that goes into our next major topic, exclusions. So in your insurance contract, there will be a list of generally very confusing exclusions. And sometimes one provision of the contract will discuss what is covered and another provision will discuss an exclusion, and the two somewhat contradict, or sometimes you'll even have 3 or 4 sections that all cover the same type of damage or the same waiver or exclusion or whatever it happens to be. And so you really need to know what is covered and what is not covered by your insurance contract. And that is one of the main areas where we see disputes. And that, as well as the cost of whatever damage is to be covered. And, knowing those sections is just absolutely paramount. And also knowing where the holes in your insurance company's interpretation or your own interpretation can fall into, where these holes are. And a lot of them are dealing with terms, or if they're contradictory, contradictory, or whether or not they are ambiguous. Ambiguous terms is a very big deal in any kind of contract law, that if something is unclear, usually it cannot be taken against the party or the person who did not draft the contract, which can be very, very useful. And also in dealing with this, you're dealing with an implied term, okay? You also have implied terms in contracts. Those are very, very limited now because so much has been codified in statute or common law, and so much is actually laid out in the contract. But one of them is, again, good faith. I've mentioned this previously. And when you're dealing with good faith, is they have to make a good faith effort to come out and properly evaluate your claim. They can't just try to go the most cost-effective option for them or ignore damage that has been done to your property or to you. And so whenever you're dealing with an insurance claim, 1, notice, 2, know what the terms are, 3, understand what is covered and what is not, and 4, understand that whenever you're dealing with a dispute, that you need to understand where the vagueness is in your contract, and then also understand things like implied terms. And so, like I've said before, is if you feel like you're having a disagreement with your insurance company, then usually it is open to discussion and you can ask these types of questions. You always have a right to ask them, but you're more likely to get a thorough answer and be able to have that very detailed discussion with your insurance company. If you feel like you are meeting opposition to everything you are requesting, everything you are asking to be done, then more likely than not, it is time for you to seek legal advice.
So the other part of that is, Chris mentioned that insurance companies are becoming more and more sophisticated with their contracts. And so what insurance companies do is they do risk assessments every few years and see where the majority of their claims are coming from. And they try to put clauses and exclusions in their contracts to address those so that, to be blunt, they don't have to pay that claim next time it comes up. So you've got to be very careful with that. I've talked about in the last show the duties of the insurance holder. So you hold that contract, you have your property protected under that contract. You're going to have to prove that that property exists if there is a claim. So you need to be very diligent in documenting that property. Take pictures, serial numbers, whatever you need to do. The other thing I would advise is not keep that inventory in your home. We've seen in the past homes getting destroyed by fires. Well, where was that list of personal property? It was in the home, so it was destroyed. In today's digital age, there's really no reason you keep it in the cloud. Some people around here don't trust the cloud very much, right, Chris?
That is absolutely correct.
Not to name
But
names.
it's a great tool to make sure you're documenting everything, to make sure that if something happens to my home, whether it's tornado, flood, whatever, and all that stuff, all that proof gets damaged, and all my property gets damaged, that I can prove to that insurance company that it existed, because they're going to ask, and they're going to want that inventory before they pay a claim on personal property. So keep that in mind. I know we're talking about risk here and things like that. One thing you should know, if there is a disaster, and this is off the subject a little bit, but know where your electrical turnoffs are, know where your gas turnoffs are, know where your water turnoffs are. You've got a responsibility as a homeowner to mitigate some of those damages if you can. So, you know, don't leave that open for the insurance company to say, well, you should have turned off the gas, you knew it was leaking, or you should have turned off the water and your house wouldn't have been completely flooded. So know your home and know those things that you can do to what's called mitigate your damages. The other part of this is when you're talking insurance companies and homes, what if you're a renter? You need to have personal property coverage when you're renting. The landlord is required to have property coverage on the home. So if you don't have that personal property coverage, you cannot rely on the landlord's policy covering your personal property. So you need to make sure those coverages are in place so that you're protected. And that way, the only thing at that point you have to worry about is any type of exclusions that are involved.
Yeah, and just to kind of follow up on that, well, number one, yeah, I do not trust technology generally speaking, but it is good advice, despite your preferences for technology, is do not keep your insurance documents, your property list at the same place that you are insuring, because you're insuring it in case something bad happens to that location or that piece of property. So if something happens to it, you don't want all of your proof stored with the very thing that you are insuring. And we do see that quite a bit. Now, there are some arguments around that. We're very good at doing that, is coming in and going, Well, it's a house. It's going to have certain things in it, generally speaking. We've had that argument come up numerous times, and we are good at it. Bennett, you especially. I love watching him do that. It is a good time. But if people can kind of start to notice that there is an underlying current of things that you need, okay? And these are basic principles of law. We don't expect, our viewers at home to understand all the nuances of this. What we do expect, or what we hope for, as you're watching this, to get some of these principles of law. Number one, notice if something happens, let somebody know, especially if they are going to have an obligation to pay for it or otherwise cover it. Number two, knowledge. Know what you are doing. Know what is expected of other people to do, and know the terms of any agreement that you enter into. And so, again, notice, knowledge, and then also mitigation. So, such as keeping your property list off-site. Do the things that help limit or prohibit further harm from coming to you or your property. And so that's what it always breaks down to: notice, knowledge, mitigation. And so these are three basic principles I cannot strain enough and cannot emphasize enough, is that if you are ever confused, that's why we keep saying, at certain times it's good to come and see an attorney. Because as you're looking through these things, as you're trying to figure them out, whether it's on the personal side, the insurance side, the business side, is that a little bit of knowledge up front can prohibit so much harm on the back end. And so we always advise people as you're going through these things, if you're uncertain, ask someone. And ask someone with knowledge of this, knowledge of, where these problems occur, where the disputes occur, and how to help avoid them.
Thank you, guys. I think a good takeaway is to review those insurance contracts and make sure that you're fully covered. So thank you, guys.
Hello, and welcome to Legal Minute with Mickey Gentle of Johnston, Moore, and Weston. Today's topic, custody issues.
Clients frequently ask me, what is the age when a child can tell a judge where he or she would prefer to live and the judge be bound by that? In Alabama, that is simply not the case. The judge is not bound by the wishes or preferences of a child. However, the child can, upon reaching sufficient maturity, tell the judge his or her preferences. The judge is actually bound by the child's best interest in the initial custody order. In determining the best interest of a child, there are a number of factors that the court must consider. In Alabama, there are two types of custody: legal custody and physical custody. Legal custody is essentially the right of the parents to determine certain issues about the child's upbringing. This includes education, religion, and health care. Physical custody essentially refers to where the child lives on a day-to-day basis. In Alabama, the courts typically try to consider true joint custody first, joint legal custody, and joint physical custody. In Alabama, courts normally consider joint legal and joint physical custody and seek to award that or rule it out. In any case, courts assume that the best interests of children are served by significant contact with each parent.
Let's dive into a couple questions that we have submitted. So our first question is going to be, I found out that my dad left a will, but my stepmom will not show it to us. How are we going to handle this situation?
Well, that is a probate question, so that's going straight to you, good sir.
Let's go to the man with the answer.
I want no part of that.
There's unfortunately, this does happen quite often, that there's someone holding the will for someone who's deceased, and none of the other heirs or potential heirs know where it is, or that individual will not give it to them. So first off, if they have to file that will for probate, they're going to have to give notice to any heirs involved, which if you're an heir, it puts you on that list. They're going to have notice. The probate court can make them at some point show you that document. You have a right to that as an heir under the law. If you're listed on there as an heir, you have an absolute right to review that document. sometimes you might be disappointed when you get that chance, just to forewarn you. But there's a lot to unpack there, but essentially the law is going to require, if in this case, if she's going to probate that will and give out the property as per the will terms, she's going to have to go through the probate court, going to have to give notice and to known heirs, and she will also have to give notice to if there are any unknown heirs, if she doesn't have the address of heirs. So there's notice requirements under the law that are going to protect you there. And you may contact an attorney. In Madison County, the Madison County Bar Association has what we call a will search. An attorney can submit the person's name, their last known address, and the date of death of that individual who's deceased. And most attorneys in North Alabama are members of that bar association. They'll get that notice, and if they do wills and estate planning, they'll be able to research their database and see if there's a will there, and they can get a copy of it to you, because you have an absolute right to that.
So I'm going to add into that, but on the exact opposite end of the spectrum, because Bennett is an excellent probate lawyer. I've seen him do it. I usually will avoid probate court if I can. Nothing wrong with it. It's just a little bit outside of the areas of law that I enjoy litigating. So some ways to avoid this issue. Number one, if you have a will, give a copy to everybody who is an heir. Not an original. Do not have them, do not have a bunch of original signed copies of her will. We definitely do not advise that. But definitely have copies out there, because in certain circumstances, a copy can serve in lieu of the original if someone is, well, frankly put, hiding a will, which unfortunately really does happen quite a bit. The other thing is, there are lots of ways to have things pass outside of probate. Number one, via contract, which is what I personally enjoy. So your bank accounts, your life insurance policies, a lot of other types of insurance payouts or annuities, or state payouts, or things from your employer. If you do happen to pass, is that those a lot of times will pass outside of probate and through contract. So basically anything where, as part of signing up for it, you have to name a beneficiary. That does not pass through probate unless you do not assign a beneficiary. Another way is trust. So basically making someone a trustee, giving it out as gifts. These are a lot of different ways that you can have things pass outside of probate, which is my personal preference. But, I think me and Bennett disagree on that a little bit. But reasonable minds can and will differ.
Well, when you come to us for estate planning, the whole idea is to try to avoid the estate having to be probated. And as Chris was saying, there's a lot of ways to pass property without it having to go through the estate. And so come see us on that. We can talk you through that. We can see what your goal is with your estate plan, what you're trying to accomplish, and all that. And then we can talk about what's the best fit is for you, because every estate's different. There's a lot of things to consider when you're talking about it. There's tax consequences to consider. So, set an appointment up with an attorney, go see them, talk to your CPA, tell them what you're trying to accomplish, and put that plan together to work for you, so that you know that this is what I'm trying to accomplish. When you pass, it is going to be accomplished. And I will say also, a misnomer in the community or everywhere, nobody wants to talk about the end of life planning. Young people need to consider that, making sure you have things in place, especially young couples with children, because hopefully nothing tragic like this happens, but if both parents should perish, who's going to take care of those kids? You get to plan that ahead of time. So don't leave that to chance. Don't leave it to the state to decide. Make sure that your wishes are met in all these processes, and we can help you with that. Any attorney that does estate planning can help you to take care of all that. So see an attorney and make sure you're prepared.
So, a good piece of advice is also, on the things you're not allowed to do. So for my personal estate planning, Bennett had to talk me out of just ordering that everyone got a taser, and whoever last man standing got all my stuff. So, you know, there's certain things you don't want to do, such as put everyone in criminal liability. So, you know, thank you for that, Bennett. Saved me and my family a problem.
Thank God for attorneys.
Exactly.
All right, well, great answers, guys. Let's go into our next question. So our next question has a little bit to do with personal injury. If you are hurt or someone was hurt at a store, but they did not go to the doctor right away, can they still sue them for their pain and suffering?
Okay, so this falls under tort. And so the answer is yes, but you may not win. It doesn't mean you won't, but this definitely causes a bit of an issue. So in Alabama, at least, if we're talking about a slip and a fall, you're talking about negligence, water on the floor, maybe some material left out. And so you actually have 2 years to file a lawsuit from the date of injury on that. There are some additional claims you can put in depending on the circumstances, but just to keep it simple, that's a general negligence claim, okay? Something was left on the floor, water, whatever, and you've slipped and fallen. Now, there is no requirement under the law that you immediately notify wherever you slipped and fell, okay? But remember, again, one of the main things we're talking about on this show, and have been for a couple of episodes now, is the fact that notice, knowledge is mitigation, okay? And if you've not put them on notice, well, how do you know anyone is aware that you slipped and fallen? How is anyone aware to take photographs, to investigate this, to check? Now, again, in a grocery store or somewhere that has video cameras, it may not be a problem at all because it'll be on camera that you slipped and fell, in which case, you know, get your treatment, do what you need to do, go home if you're in a rush, and, you know, you'll still be able to press, you know, your lawsuit within 2 years and still collect, provided you can prove it. So again, something right along the lines of a child support question that we had of someone buying a new truck and whether or not that necessitates or is dispositive in changing child support. It comes back down to proof. It's not prohibitive. You're not stopped from filing a lawsuit if you slip and fall and don't put anyone on notice. Definitely not. But what proof are you likely to have? And so, and also, how long are you talking about waiting? I mean, if you wait 1.5 years, probably most of the security footage is going to have been overwritten at that point. And so you being able to prove that that slip and fall either A, occurred, or B, caused whatever damage you have becomes harder and harder the farther away you get in time. And so again, a general principle of law, put somebody on notice. Always a good idea. But again, if you're talking 4 or 5 days, probably not a problem. If you're talking 18 months and you go, well, my hip hurts and I think it came from this slip and fall, well, you need to be aware that getting proof of that claim, meaning that it happened there, becomes more difficult. There's also the fact that a defense that comes up is what's known as intervening variable or intervening cause, meaning that you've put no one on notice that your injury occurred. It's been 1 year, 18 months. Well, one of the defenses is going to be, well, they must have injured themselves in some other way during that 18 months because they didn't tell anybody that this was a problem until so far after the fact. Now, again, if you have medical records from right afterward, you had just left, nothing else had happened, but this is where you get into a lot more litigation, depositions, which are questions under oath that are not in the courtroom, that are done in front of a court reporter, and you get into a lot more nuanced litigation and argument and negotiation whenever you're dealing with something after the fact of which nobody was put on notice. Yeah.
I will say this, best practices, report it right away. And here's why. These businesses, and I can tell you this unequivocally because this is the way I advise businesses, they're going to have sweep logs, mopping logs. They're going to have systems in place to prove that they've done nothing wrong. And that's their whole goal. But let's stop right there a second and talk about who really is going to have to pay that claim. It's an insurance company. So again, you're back to dealing with insurance on this. So make sure you report it. Make sure you if you can, if you're injured badly enough, it's not going to be a problem having proof because they may have to call an ambulance or whatever. But if somebody's with you, make sure they document and put it on video or take pictures. Everybody has a cell phone with this capability. Use that to your advantage. But don't let the evidence of this being the store's fault spoil. You've got to take action for yourself and make sure that you're protecting yourself. Otherwise, you're going to get denial after denial, then you're going to have to come see an attorney, and that's a long, arduous process. If we have to sue, the insurance company is going to pay their big gun attorneys to come in and try to fight us, which is fun, by the way. But yeah, it's one of those things where you can help yourself. Obviously, again, if it's a serious injury or if you're hurt pretty bad, don't waste time doing this kind of stuff. But, you know, minor injuries or something that could turn into a major injury, you know, you could tweak your back and not know it and have slipped a disc, and that's going to be a major injury down the line for you, something you're going to have to deal with most likely the rest of your life. So, again, make good decisions, but I would say report it as quickly as you possibly can. Don't delay for any other reason.
Is there a statute of limitations that our viewers should keep in mind as far as how long they have to report the injuries? You guys definitely expressed that the longer we wait, the harder it is to prove your claim. But how long do we have to submit our claim of injury?
There's no real statute of limitations on that, you know, at least not for general slip and falls. If you're dealing with a workman's comp claim where you are an employee there, that is an entirely different question. And we'll definitely have some follow-up episodes dealing with workman's comp. But there's no statute that says you have to give notice within a certain time frame somewhere. You know, but again, if you don't, you're dealing with spoliation of evidence. You're dealing with a lot higher difficulty level in getting recovery. And so, but the one thing you do have to do is make sure that you file any claim for general negligence within 2 years of the date of occurrence. And again, depending on the circumstances, you can have other statutes. If it is something that it was wanton that they left there, something that was hidden, something you could not have discovered, you know, depending on the location. But that being said, you know, we're talking more about, you know, you're in a place of business, you slip, you fall, you hurt yourself. You're not required to give notice, but you are making it a lot harder on yourself if you do not. Because then you're counting on your proof of this injury to come from someone else that isn't you, which is much more difficult.
So in the end, don't wait, report immediately, and definitely hire an attorney to help you to get the best possible outcome for your case that you have. Well, guys, thank you so much for joining us today. That's all the time we have for today's episode. And thank you guys for joining us tonight. We look forward to hearing your questions that you have for us. Feel free to email them to legalhelp@jmmtlawfirm.com.